You're listening to the Valley Current.
Hey, David, you look great. What's new?
Well, everything, lots of things. How about you?
Yeah, you're staying busy, huh?
Yeah, the spring was very busy, and I just finished. I was doing a NETA podcast, and it looked like it was going to go. We were getting so delayed on technical stuff. I thought it would go late, but it didn't. So
that's the National Institute of Trial Advocacy, right?
That's the one where you took the class in Las Vegas. Yeah,
that was a great class that you led. It was a great group of people. Did you repeat that online? Is that what you did recently?
Well, yeah, I did that several more times live, and then COVID hit and we just made it an online course. It's actually shorter and more focused on either storytelling or presenting. They're two different classes now. And this was basically a podcast to promote that. So okay. That's what this was. Yeah.
So it's interactive. The storytelling one is interactive, or the presentation is interactive? They both are.
I try to make them as interactive as possible. But I've also been doing, a fair amount of speaking at legal conferences and working with firms and working with, short seminars and stuff like that. So it's been very active.
But it's all right there from your room, from your office, right? From your home?
Well, no, the spring, the majority of it was actually live stuff. In 3 consecutive weeks, I spoke for the Missouri bar, the North Dakota bar, and the Nevada bar. And before that, I had done this in-house thing with State Farm and a firm in Grand Rapids, Warner Norcross, and all of that stuff was live. I mean, I had to fly there and do it, which I don't mind at all,
And you didn't get COVID either. You didn't get sick.
No, miraculously, all that airport time, and managed to skate past. So
that's great. So you had some questions you wanted to pitch to me, and I thought we should kind of create a frequently asked question kind of list. You had some questions that I sort of deferred because I was in the middle of some busy stuff myself. But I remember how this started, right? You had a bunch of questions you wanted to pitch, and
let me see what I asked about then. Just a minute.
I mean, I've got other topics I want to raise with you, some of which I've forwarded a couple of emails about, which is it looks like court reporters or court reporting firms are now getting into jury focus groups and jury mock trials. They seem to be extending their services in adjacent fields that traditionally they've not really gone into, but I imagine they're worried that the court reporting type work may be shrinking as technology starts to take over recording of depositions, recording of witness testimony and the like with automated transcripts. That seems to be what will happen over the next 10 years. I don't know what it means for official court reporting. I mean, you read a lot of transcripts in what you do when you help lawyers put together the themes that they have in cases. I know you often take a case file, including all sorts of transcripts from depositions and other hearings, and you synthesize that data. That's part of what you do when you do a big project, right?
Yeah, and in a case I'm working on right now in Wyoming, I'm involved so early in the thing that I'm able to actually help them with the broad strokes of the story before any discovery happens. So it's there, you can kind of spin like, how are we even going to ask questions and depositions and everything to get the story we're looking for? And that's ideal.
That's ideal. Sure. That's like constructing the play before the play is written, right?
Once I'm having to deal with existing material, depositions that are already done, you're like, well, how do we make our story out of this stuff?
Right.
And sometimes you can't always. So, yeah.
Let me mention something because I found it amazing. There was a jury verdict in Texas in a state court wrongful death case against a big internet carrier, Spectrum, for $7 billion with a B of punitive damages. $7 billion. Can you imagine being the defense lawyers in that case? Apparently an 83-year-old woman was robbed and murdered by a Spectrum employee who took advantage of her, I guess, and killed her in her home. And ultimately, he was convicted of the murder. But Spectrum was held liable for, I guess, the negligent hiring of this guy, or the negligent retention, or lack of management.
$7 billion?
Yeah, to the estate and to, I guess, the next of kin. There were 5 plaintiffs. I just saw it in the news yesterday, and I thought to myself, I should raise this with David, because, that's the kind of case where I would think a company like Spectrum would really want to make sure that its defenses will play, and would want to make sure that they really have their defenses down and tested and all the rest, including the mock trial focus groups and the like. 7 billion is probably the biggest number I've ever heard for an individual. And it's not like she was Elon Musk, who obviously has earning capacity of billions of dollars. He's the richest guy on earth. He's worth like 250 billion or something. It's not like it's that kind of person. It's a retired 83-year-old mom. I don't know what her rest of her life would likely have been. Most people would say probably not beyond 90 or 95. But 7 billion of punitive damages is what came over the newswire yesterday, and pretty significant.
What I do with lawyers is it's very focused on how once you've got your hands around the facts of your case and presumably what the other side is going to say, how do you shape it so it actually lands with a jury? So there is a certain amount of jury psychology. I mean, there's people who work on just that. And I should probably get, as we talked last fall, more into that kind of, jury consulting, and at least be kind of a piece of their division. But I'm finding that the link that I occupy the best is where it's like, look, you may know all your data on your jury, you may know all your facts and everything, but you still can't communicate it right. And so it falls flat. So something like that case, it's like I'm sure they had zillions of dollars put into jury research and somehow still lost, like, how is that even possible?
Yeah, it's hard to imagine a worse loss. I can't imagine what these lawyers who defended the case are feeling today, right? Or yesterday when they got the news, right? It's hard to imagine. Probably the initial thought is there must be a zero or several zeros mistakenly added to the verdict, but the verdict was actually handwritten out to say 7 billion in exemplary damages. I
guess this leads to the larger point that I am kind of focusing more and more on now. I think that you can't separate legal storytelling, like a case story that you have to tell the story of this case. You can't separate that from the cultural zeitgeist of myth making. And we think we can. Just the same thing, like you say to a jury, you can't let your emotions sway you in this case, as though you can actually control that. It's like, of course you can't. So a case like you're describing there sounds a bit like the jury was like, you know what, corporations just need to pay. And you can try to kind of weed that out in voir dire and all that stuff, but still it's part of our it's seeping so deeply into our minds, like certain cultural myths that we live under. I don't know how you ever really get it out of the courtroom,
Right. I mean, people come to the table, jurors come to the table, judges come to the table with all of their pre-existing biases. I'm putting it up on the screen because I did circulate it among everyone in my firm as, this is what it really means to have a bad day if you're a defense lawyer. Yesterday in Dallas, Spectrum, which is basically the company that provides cable services to a lot of America, was tagged for $7 billion in exemplary damages in a state court, essentially wrongful death action due to what they call the preventable death of an 83-year-old woman who was taken advantage of by, I think, one of their employees. I think that's the basic story.
Yeah, it does. It sounds like there's got to be something else to this story, because that just seems insane.
Right? It's a big number. And if you look at the number, they literally spelled it out. Like
$7 billion.
I mean, I've never seen that in a verdict. You know, look, the nature of the wrong, the character, the conduct, the degree of culpability, blah, blah, blah. The net worth of Charter. Charter is the parent company. I mean, I think it's got kind of a $300 billion valuation. I mean, that would be the other question. How do they decide that it's that big of a number? Like, they must have looked at Charter Communications is, looks like it has a market cap of $79 billion. So this would be like a 10%.
10% of their value. Yeah.
10% right. Of their value, of their market cap. That's the entire market cap of the company. I mean, that's a huge, huge number. This is obviously now being reported in the Wall Street Journal and elsewhere. Presumably the stock will take a hit. Presumably there may be class action cases because shareholders will say we had no idea that there was any of this going on that should have been disclosed. It's funny, it says $7 billion and 0 cents, like, just to get
like
cents right. Yeah. Right. And then they allocate it pretty much across the 5 different plaintiffs, which is the estate. And then I guess certain kids here that are listed, Charles, Cindy, Cheryl, and Charlotte, all the names start with a C. That's kind of funny. Mm-hmm. And William Goff was the personal representative of the woman's name is Miss Thomas. And sounds like a pretty gruesome case. But it also sounds like Charter didn't do something correctly. I mean, whatever it is, it's sort of hard to know. The defense lawyers must have been pretty shocked by the outcome. I don't know what you have to say. There was some sort of forgery or alleged forgery or found forgery where Charter tried to create an online arbitration agreement that they said that Ms. Thomas had signed, but the jury found that that was false. So, it's kind of amazing. Her name is Betty Jo McLean Thomas, entitled to $7 billion in exemplary damages based on this Dallas, Texas state court jury. But yeah, I thought it was a good intro to why do people test themes with you and with mock jurors and with focus group members, because you can get a surprise like this. Now, maybe it only happens a few times a year, but it does happen, right?
Yep. I mean, they're going to do what they're going to do. I guess if you're asking me about this type of, not just this case, but the broader idea of testing theories and themes and testing with juries, I always go, yeah, I mean, but that's not the whole story. I mean, we live in such a data, we're so in love with data. We're so in love with well, you don't know until you've tested it and got the data on the spreadsheet, and then you know for sure. And I'm like, yeah, with lots of things, that's true. Not necessarily with this type of thing, though. I worked on a personal injury case last fall, so not a $7 billion thing, but it was a $9 million, I think, was what we were after.
Right.
And that lawyer did 5 focus groups that all came back with really consistent results in our favor. And then we did the real trial and ended up with 1. I mean, they did award, but it was 1, not 9 million. And that jury, we think, was just very hey, it's a personal injury tort case. That plaintiff is just wrong. That plaintiff is just faking. That, they just walked in the door with that. How are we going to test? We already tested all these jurors
5 times.
How are we going to know that this particular group was nothing like any of the test groups? I mean, that's just how it goes. So
yeah, I mean, if you don't get a range, you probably start to wonder whether your mock jury selection is in fact reasonable. Like,
well, it also,
right?
I'm not sure in that case that, because I wasn't a part of all those focus groups, I would help him with the results of the focus groups and like, well, let's recraft the thing. But I'm not sure those focus groups were introduced to the defense side of the story. I think they were just hearing his side, which was compelling. But when I sat in that, it was one of the few cases I got to sit and actually watch the part of the trial.
Right.
I heard that was in-house corporate defense on the other side. I heard that guy's opening. I was like, uh-oh, that's really compelling. And that might have been it. They just had a stronger case, or they just had enough to counterbalance our strong case.
Right. Usually you want, if you're being fair, you want the defense side of the case to be put in as strongly as possible if you're a plaintiff. Like if we're doing a focus group for a plaintiff, I will typically do, as the more senior person in the firm, the defense side of the case, because we want it to be the a fortiori case, which is the stronger case. We want it to be like, let's really battle test it and see what comes out of that. We don't want to pussyfoot around and pretend like the lawyers on the other side aren't going to do a good job, because they are. And so that's a much better acid test than just sort of, convincing yourself that you've got it right and the other side's got it wrong.
Well, one of the things that they brought up, which I think wouldn't have necessarily happened in doing what you're describing, where what you're describing is like, let's go for their like best possible argument, Well, what this defense lawyer did is he started to zero in really hard on the whole, let's talk about this expert, the one and only expert that actually has diagnosed this guy with a brain injury. And let's look at that guy's history and how many other times, like that was, he just started to pull this thread of like, the one expert is not credible.
Right.
And I'm not sure that if you are doing both sides in the focus group yourself, that you're going to tend to do that, Right. Because that's really a weak spot.
Well, he was smart enough as a defense lawyer to figure out the weak link. Yeah. And then really hammer the weak link until the link broke. Yeah. And I guess that was worth $8 million in savings on what was the predicted outcome, right?
Well, sure. The jury still felt like they had awarded something. They didn't know that 50% of it went to the lawyer and that plaintiff really didn't get that much.
Right. Ultimately, you have to wonder, is that a case where you want to have 3 experts, where you want it to be so burnished and so strong, or the links to be double chained or triple chained. Yeah. But at some level, if you add more experts, you add more potential for confusion.
Right.
If each expert is slightly different from the other, it becomes like who to believe at this point, right?
But I think that the thing, though, and I was just talking about this on the NITA podcast, is that at the end of the day, the general kind of thing I'm saying to people here, if we're talking to people here, is really thoroughly test the storytelling of your case. Don't just test litmus test a bunch of themes or kind of just organize your facts or whatever. You've got to really brainstorm a story. Like, what is the story we hope we can tell? So you're doing it early enough in the process that you can actually go into discovery and now get that information if you want. I mean, that's the key to really making it work, I think.
Right. Yeah. I mean, the truth is, you do something that is valuable and is required, but most lawyers don't know about it, or they don't want to believe that they should be sharing the information, or they don't have a client that's willing to pay for what might be called those auxiliary services, or they don't have a firm, if it's a contingent fee firm, that's willing to pay for those auxiliary services.
Well, that's exactly what I run into, is that what I'm offering, what I can do really, really well is critical. But because it's a little outside the norm of what they're used to paying for, they go, well, why do we need to pay for that?
Right.
And when they do, though, they immediately go, this is central, this is critical, and it's absolutely the cornerstone of how we're going to pull this whole thing together,
Right. Well, I wanted to pitch another angle at you because I'm sure you're following this big Twitter case with Elon Musk. We mentioned them a minute ago. Yeah. I just wonder, is that a kind of case that's a complicated corporate merger agreement with a lot of dry contract language and no jury, a judge sitting in equity in the Delaware Court of Chancery? Would you imagine that being a case? Let's say Elon Musk called you, or the lawyers for Elon Musk called you and said, hey, David, we really want 3 points to land or 1 point to land with Judge, I think her name is McCormick, Judge Catherine McCormick, who sits in Chancery. We'll give you some information about her. She's decided a case like this before, but with smaller numbers, smaller merger. Would you do that kind of case, that kind of business case as well, where there's no jury?
Oh my God, yeah.
So tell us, how would you go about that? Say Elon Musk's lawyers call you and say, hey, we want your help in landing and helping us land what we think the best arguments are in favor of our position.
I'm not really sure I can speak to any specifics in that case because I don't know it that well. I just know the very broad strokes of that case. But in the more general thing that you're asking about is, yes, I mean, classic jury trials with a plaintiff and a defendant. I mean, that's just not there. When that happens, it might be really small amounts of money, or it just doesn't happen at all. It always settles before it gets there. So a contract case, a business case, or I've worked on some securities fraud cases.
Right.
They're all they really are about is, can you make the critical information as simple and direct as possible? I worked on this with this firm in Grand Rapids. They had me there for 2 days, and what I did for 2 days is sat in a room, and each one of them came in like it would be a team on this case and team on that case, and they'd all come in for 1 hour and say, "Here's basically the case." And all these were bench trials. None of them were jury trials. And how do we tell this story? And I would, in the space of an hour, go, oh, you got to zero in on this part of the argument or this part of the facts. And then here's how we're going to simplify that section so that it goes 1, 2, 3 and makes sense. And the 1, 2, 3 might have a forward movement to it from like bad to worse to catastrophic. And
so you did like a lightning round inside of a firm with multiple cases, multiple groups, multiple teams. Like, you have to be really good at being able to synthesize, let's say 10 cases over 2 days, 5 to 6 to 7 hours a day with maybe a lunch break. That's a lot of volume, but I could see how a firm could get a lot of value out of that kind of 2 day, let's use your time really well across and spread the price across 10 cases, right?
That's exactly what they did. And
that's really smart.
Some of those cases, I may still be involved. Like the client may hire me to do the full out treatment on that thing. And all of these, or the majority of those cases, are huge defense cases. So they're like, there's some huge money on the line in some of those things. So it's a big company that is willing to do whatever it takes to get all the kind of ducks in a row to make the thing happen. But what my service was for those 2 days was to say to a team of lawyers that may have gotten themselves kind of deeply in the weeds and they can't see it anymore. They're like, what's the center? What's the focus of this case? I'd say, just talk to me about it. Just talk to me about it. Just talk.
Right.
And they're like, well, it's this, and it's this guy, and this one, and this thing happened, and then there's this whole, and they'll go like on some super deep dive on the technical elements. And I'm just kind of sizing it up and saying, like, what's the through line? Who am I supposed to care about? Who is like the villain in the story?
Right.
And then these technical elements need to be able to be summarized in like 60 seconds. Can you do that? And here's how I think we can do that. That kind of stuff, they go, oh. And then it starts to come together.
So you kind of pull them out of the rabbit hole and say, look, there's an audience, and the audience has got to hear the point, because even if you think you've made the point in your own mind, it may not land at the receiving end. You may be thinking that it's made, but it's not, right?
Yes, exactly. And the land that what you're talking about is what we got way into, which is a lot of them would come to me, and this is not just this firm, but many where it's not a jury trial. It's maybe it's just a motion. Maybe it's something where it's just two legal minds. The lawyer and then the legal mind on the other side is the fact finder. It's a mediation, whatever it is.
Right.
We go, okay, that fact finder, especially if it's a judge, is like, please don't tell me a story. Please don't make this into an emotional appeal. Like, they don't want that.
Right.
But I always say to them, okay, well, if it's as simple as just presenting the facts, and you have the right facts, then why don't you just show them the page of the manual that says, I am officially right and they are officially wrong. And well, we can't do that. I know, because it's not that simple.
Right.
There's your facts and their facts, and say it's all even. Say it's absolutely even.
Right.
Why would that judge go your direction? Intuitive sense of it being intuitively correct.
Right.
And how do you get that to happen? You shape it like a narrative, but it doesn't sound like Hansel and Gretel. It just is shaped like a narrative. And that's the sweet spot that we get in.
Tell people how they could reach you if they want your services or want to learn more about it.
asimplemessage.com. That's asimplemessage.com.
That's your website.
And that's my website. Click the legal tab, and there's ways to contact me all over the place on there.
Great. Thanks, David. We'll pick this up again. I'm sorry we ran out of time, but it was really useful. We'll talk about this again down the road, okay? Take care.
All right. Great, Jack. See you later.
Bye-bye.
Tune in next time on The Valley Current.